Welcome to our podcast. My name is Katia Zigoulianou, and I am joined by my colleague Nefeli Bernitsa. In today's episode, we're diving into the recent changes introduced by the Listing Act to the market abuse regulation. Whether you're part of the industry or simply curious about how these developments might impact the regulatory landscape, you're in the right place.
Thanks for having me, Katia.
My pleasure. Let's start with the basics. What is the Listing Act?
The Listing Act consists of 3 legal acts designed to make EU capital markets more uniform, accessible and attractive for EU companies, in particular small and medium-sized enterprises.
Does it affect any other existing regulatory frameworks?
It actually does, and I will elaborate. The Listing Act entered into force in December 2024 with a staggered implementation for certain provisions, which means changes will occur in phases rather than all at once. This allows for gradual rollout, which can help manage the transition more smoothly. The Act amends several key regulatory frameworks, most notably the Market Abuse Regulation, which we're here to discuss today, the Prospectus Regulation, and the Markets and Financial Instruments Directive, MiFID. In the case of MAR, changes are directly applicable in Greece. The targeted changes ease compliance burdens for issuers while preserving high standards of investor protection and market transparency.
Diving into the substance of the changes, one of the first things that stands out is the broadening of some definitions. There's an interesting expansion of inside information in relation to front-running conduct. Can you explain what has changed here?
Absolutely. Under the previous regime, the definition of inside information covered only the persons directly responsible for executing orders, like traders or brokers who are handling a client's order. Under the new rules, the definition has expanded. It includes people who might have access to that inside information indirectly, like individuals conveying information on behalf of the client, or those managing a proprietary account or a managed fund. Essentially, the new definition aims to capture individuals within the information chain who may become aware of a potential future order.
Okay, that's a viable point. Another key change has to do with market soundings and the rules about when and how inside information needs to be cleansed. Can you walk us through these amendments?
Of course. So the Listing Act has expanded the definition of market soundings to include cases where there is no public announcement of a specific transaction. This change enables market participants to benefit from the safe harbor provisions, even when inside information is disclosed outside the context of a particular deal. Regarding the cleansing obligation, under the previous rules, the disclosing market participant, DMP, would have to inform recipients that the information was no longer inside information, even if that information had already been made public. However, with the Listing Act, DMPs no longer need to cleanse the information once it's already been publicly disclosed.
But I sense this may not be the biggest changes in market sounding, right?
That's correct. MAR has always had a detailed and somewhat burdensome record-keeping and disclosure regime around market soundings. The Listing Act clarifies that this regime is an optional safe harbor.
So it's no longer mandatory for market participants to comply with the rules for market soundings?
Exactly. The Listing Act now clarifies that the market soundings regime and the requirement of Article 11, Paragraph 4, things like getting consent from recipients, keeping detailed records, and so on, is optional. The market participants can choose whether to follow these specific rules. If they do, they can benefit from safe harbor protections. This means they can disclose inside information as part of the market sounding process, and as long as they meet certain record keeping and information disclosure requirements, they're protected against accusations of unlawfully disclosing inside information.
So essentially, if they follow the rules, they are covered legally. But if they don't?
If they opt to skip the requirements, they don't get the legal protection of the safe harbor. However, and this is important, non-compliance with the optional market sounding regime doesn't automatically mean they've engaged in market abuse or unlawfully disclosed inside information.
Got it. Moving on, there's also a change to the rules about delaying the disclosure of inside information. This is something issuers often struggle with, balancing the need for transparency with protecting their legitimate interests. What's the big shift there?
Great question. In the past, issuers could delay disclosure under 3 cumulative conditions. Number 1, if immediate disclosure was likely to prejudice the issuer's legitimate interests. Number 2, if the delay was not likely to mislead the public. Number 3, if the issuer was able to ensure confidentiality. The Listing Act now replaces the vague second condition around potentially misleading the public with something more specific. The information being delayed must not contradict any previous public announcement or communication on the same matter. This change offers issuers greater legal certainty and helps avoid confusion or mixed messages.
Let's talk about protracted processes, those long, drawn-out negotiations that could involve mergers or acquisitions. There used to be a lot of confusion about when to disclose information during these processes. What has changed with the Listing Act?
This is one of the most significant changes, actually. The Listing Act now says that issuers don't have to disclose every little step of a long process, just the final event, the end result. For example, in the case of a merger, the issuers should disclose information as soon as possible after management has decided to sign the merger agreement and the key terms have been agreed upon.
So this really clears up a lot of ambiguity. Companies won't be forced to disclose information that might change during a long negotiation. Am I right?
That's correct. Previously, companies had to decide whether to disclose intermediate steps, which often didn't provide any real value to the market and could even mislead investors. Now, they only need to disclose once things are set in stone. It's worth noting that the new provisions for disclosures in protracted processes will come into force on the 5th of June 2026.
Let's shift gears now to talk about managers' transactions. Understand there's been a change to the reporting thresholds for persons discharging managerial responsibilities, also known as PDMRs. Can you walk us through that?
Sure. Under the former regime, PDMRs had to report transactions once the total value of their dealings reached €5,000. The Listing Act has raised that threshold to €20,000, significantly easing the burden on these individuals. The new regime also gives member states' competent authorities the discretion to adjust the threshold, setting it as high as €50,000 or as low as €10,000.
That's a big jump. Does this mean there will be less reporting overall?
Yes. Along the same lines, it is worth noting that the Listing Act also expands the exemptions for transactions during closed periods, namely the 30 days before financial reports. The new regime has introduced a new exemption that allows PDMRs to carry out transactions that do not involve active investment decisions by them or result exclusively from external factors. Now, transactions due to external factors like inheritance, gifts, or donations are exempt, as well as those on pre-agreed terms like options or derivatives. This is to ensure that the prohibition only applies to actual investment decisions.
Let's talk about share buybacks now. The Act also made things a bit easier here, right?
It has. The reporting requirements for share buybacks have been simplified. Instead of reporting transactions to all relevant authorities, issuers only need to report to the authority of the most relevant market in terms of liquidity.
So that reduces the number of reports issuers need to make.
Exactly. And when it comes to public disclosures, issuers are only required to publish aggregated information about the trades.
Now, I see there's been a change to insider lists, particularly for issuers in SMEs growth markets. What's the update there?
Under the Listing Act, it is left to the discretion of member states to require issuers on SME growth markets to expand their insider lists and include all individuals who have access to inside information. The aim is to enhance transparency and ensure that no relevant persons are omitted.
And finally, the new cross-market order book surveillance mechanism. What's that about?
This new system is a way for national competent authorities to collaborate more effectively across markets. It creates a unified surveillance system that allows authorities to monitor trading activity across multiple platforms. It's a step towards making market surveillance more robust and ensuring that market abuse is spotted faster.
Thank you, Maria Nefeli, and thank you all for listening. We hope that you have enjoyed this podcast. We are waiting for the finalization of technical standards under MAR. We hope to follow up soon with our podcast on how the EU Listing Act affects MiFID and prospectus regulation. If you would like to find out more information about this matter, or any other legal matter you may have, visit www.bernitsaslaw.com or reach out to us directly.
This is Bernitsa's Law Podcast, your window to the latest legal developments in Greece. This podcast is intended to provide general information and is not meant to constitute a comprehensive analysis of the matters or to be relied upon as legal advice. It is not meant to create a lawyer-client relationship. Legal and other professional advice should be sought before applying any of the information in this podcast to a specific situation.